Get ready for the dictation. Dictation will start in 5 seconds. Start. As is clear from the above, the precise charges against the respondent was of raping the minor girl Komal and thereafter murdering her. The High Court, on the basis of medical evidence, namely the post-mortem report of the deceased, found that it was case of homicidal death. There is no quarrel about the same, and this aspect is not disputed by the respondent before us as well. As far as charge of rape is concerned, the High Court observed that there was no direct evidence and medical evidence was the only circumstantial evidence which could be relied upon. It discussed the evidence of Dr. Nagori to this effect, who had conducted the postmortem on the dead body. It was found that there was swelling of 3 into 2 centimeters on right labia majora and aberration over left labia majora. It is also recorded in the postmortem notes that as per vagina examination, it was found that little finger passed with difficulty and there was no internal injury. The postmortem notes also indicated aberrations on both thighs, both knees, and bruises over legs. In his deposition, the doctor has deposed after describing the injuries that the injuries found on labia majora were possible in an attempted rape. During cross-examination, he deposed that if there was penetration of penis in the vagina, there was possibility of internal injuries. He stated in terms that from the postmortem examination, in the instant case, there was no penetration of penis in the vagina. On the basis of aforesaid, the High Court acquitted that offence of rape was not proved by the prosecution beyond reasonable doubt, and it could at the most be considered an attempted rape. The finding of the trial court recording the conviction for offence of rape under section 376 of the IPC has accordingly been set aside. It is primarily on the ground that even if it is to be accepted that in a case of rape of a minor, complete penetration of penis with emission of semen and rupture of hymen is not necessarily to be established in the instant case, the medical evidence clearly suggests that there was no penetration at all. That is the factor which influenced the High Court to set aside the conviction based on section 376 IPC. The High Court thus proceeded on the basis that the deceased was murdered and there was an attempted rape on her. It then addressed the central issue via whether the respondent could be connected with the said murder and attempted rape. It was a case of circumstantial evidence in the absence of any eyewitness. After discussing the evidence, the High Court found that prosecution had failed to establish the chain of circumstances could connect the accused with the crime. There were material contradictions and inconsistencies in the depositions of various witnesses, etc., which did not form a complete chain. The High Court has accordingly set aside the order of conviction of the trial court as unsustainable and acquitted the accused of the charges. It is inter alia held that the evidence laid by the prosecution on last seen together cannot be accepted. It is not only contradictory, inconsistent, and improbable, but also suffers from vice of improvements and therefore it sounds unreliable. Stop.